Article 3, Bill of Rights, Section 12, Paragraph 1. Any person under investigation for the commission of an offense shall have the right to be informed of his right to remain silent and to have competent and independent counsel, preferably of his own choice. If the person cannot afford the services of counsel, he must be provided by one. This right cannot be waived except in writing and in the presence of counsel. Paragraph 2. No torture, force, violence, threats, intimidation, or any other means which vitiate the free will shall be used against him. Secret detention places, solitary, incommunicado, or other similar forms of detention are prohibited. Paragraph 3. Any confession or admission obtained in violation of this or Section 17 hereof shall be inadmissible in evidence against him. Paragraph 4. The law shall provide for penal and civil sanction for violation of this section, as well as compensation of the rehabilitation of the victims of torture of similar practices and their families. Section 13. All persons, except those charged with offenses punishable by reclusion perpetua, when evidence of guilt is strong, shall before conviction be bailable by sufficient sureties, or be released on recognizance as may provided by law. The right to bail shall not be impaired, even when the privilege of the writ of habeas in corpus shall be suspended. An excessive bail shall not be required. Section 14, Paragraph 1. No person shall be held to answer for a criminal offense without due process of law. Paragraph 2. In all criminal prosecutions, the accused shall be presumed innocent until the contrary is proved and shall enjoy the right to be heard by himself and counsel, to be informed of the nature and cause of the accusation against him, to have a speedy, impartial, and public trial, to meet the witnesses face to face, and to have a compulsory process to secure the attendance of witnesses and the production of evidence in his behalf. However, after arraignment, trial may proceed notwithstanding the absence of the accused, provided that he has been notified and his failure to be a fair and justifiable. Section 15. The privilege of the writ of habeas corpus shall not be suspended, except in cases of invasion or rebellion in the public safety requires it. Section 16. All persons shall have the right to a speedy disposition of their cases before all judicial, quasi-judicial, or administrative bodies. Section 17. No person shall be compelled to be a witness against himself. Section 18, Paragraph 1. No person shall be detained solely by reason of his political beliefs and aspiration. Paragraph 2. No involuntary servitude in any form shall exist except as a punishment for a crime thereof the parties shall have been duly convicted. Section 19, Paragraph 1. Excessive fines shall not be imposed, nor cruel, degrading, or inhuman punishment inflicted. Neither shall death penalty be imposed unless for compelling reasons involving heinous crimes. The Congress hereafter provides for it. Any death penalty already imposed shall be reduced to reclusion perpetua. Paragraph 2. The employment of physical, psychological, or degrading punishment against any prisoner or detainee, or the use of substandard or inadequate penal facilities under subhuman conditions shall be dealt with by law. Section 20. No person shall be imprisoned for debt or non-payment of a poll tax. Section 21. No person shall be twice put in jeopardy of punishment for the same offense. If an act is punished by a law and an ordinance, conviction, or acquittal under either shall constitute a bar to another prosecution for the same act. Section 22. No ex post facto law or bill of attainder shall be enacted.